First of all, my name's David Roper Newman. And I recognise this is the last graveyard slot, so I hope you're paying attention. I work for Craven District Council, which is, I don't know whether any of you have heard of Skipton in North Yorkshire. It's a large, mainly rural area in that county, and apparently it's the happiest place to live in the UK, according to the press anyway. The population is under 60,000. The largest town is Skipton. We've got around 200 staff in the district, and we're across 6 sites, including a crematorium and a very popular leisure centre. A bit about me. I worked for Craven District Council for nearly 3 years, managing information governance and recently complaints handling as well. In all that include data protection and I'm the DPO, of course, but also overseeing freedom of information, environmental information requests, although I don't answer them all. That's down to the service managers, but I take a close interest and have introduced new controls to make sure that we're meeting the ICO's various targets. Prior to working for the District Council, I spent over 40 years in a central government department, previously and latterly leading on security policies. I have about 15 years experience of being involved in information security management. I've worked with the ICO and HMRC on the illegal trade in personal data as well for my sins. That was many years ago. I've personally dealt with many large and smaller serious data-related security incidents, including supporting managers, investigating incidents, providing ministerial briefings, publicity notices, and liaising with the ICO, not just in central government, but also with another organisation as well. I hesitate to say we've not had to do much of that in my present role with Craven. I can only skim through these issues in the time available, but as you will have heard earlier, there's lots of resources that you can access anyway. So, data protection reform in local government. I thought putting the bill and the regulations was quite useful because, as we've heard, you can't read one without the other, particularly in the UK, or only in the UK. Title of my presentation: Transparency, Fair Processing, Privacy Impact Assessments and Communication with the Public. That's our logo, by the way, quite a nice one, a road into the Dales, which you'll see later. When I looked at the title, I thought, well, I'll look at the GDPR, and we've got GDPR Article 12, which talks about transparent information, communication and modalities for the exercise of rights of the data subject. I had to look up modalities because I'd not come across that before, and it's a way of going about things. So it's about the way we process information, the way we help individuals exercise their rights. A lot of this is not new. I mean, we've had to communicate information to people all the time in the past. And as I think David made the point earlier, a lot of the GDPR, the Data Protection Bill, is as we are at the moment, but there's more detail and more requirements, particularly on organisations. So Article 12, what did it talk about? Well, the obligations of the data controller. So the first thing is to provide information to the data subject where personal data is collected from the individual. Again, most organisations will have some sort of privacy notice already, which outlines, what we do with people's information, why we're collecting it. But the guidance is a bit more specific, and I'll come back to that in a moment. We also have to provide information to the data subject where personal data has not been obtained from the data subject. Think about that one, because we do collect information, perhaps from other sources. So think about, that one in individual cases. And then we've got to explain and communicate the right of access, the right of rectification and erasure, restriction of processing, data portability, objection to automated decision-making, and objection to profiling. Again, I think earlier on the speakers touched on what if someone wanted to restrict our processing? What implications might that have on the services that we provide as a local authority to them? And obviously, a good example is if someone objects to our processing for council tax purposes, for benefit purposes, or for the collection of tax. What does that mean? Do they have a right to object to processing or not? An objection to profiling. I know some local authorities do profiling. Again, a lot of profiling, will be, for example, people like the supermarkets who collect information about our shopping habits. I'm not sure we do a lot of profiling in local authorities, but would anyone like to contradict me? I know some organisations do where, for example, it might be for benefit fraud purposes. No?
We have a team who support, like a family support team.
Right.
And they identify people that they might want to help by collecting information from various agencies. And then saying, these people definitely need our help, and approaching them. So I would call that profiling, but I understood under the regulations that it tended to mean like automated profiling.
Yes, it is. Yeah, it is automated profiling. There's a lot in Article 12. I'm sure you've seen it. We've got to communicate, and were many of you at Stacey's presentation earlier about the data breach reporting? Were a lot of you there? We have to communicate details of a personal breach to the data subject where it is likely to result in a high risk to the rights and freedoms of natural persons. Again, there's a lot of information. Stacey from the ICO referred to guidance from the Working Party 29, which has actually examples of data breach that should be reported. But again, in terms of high risk, we're not just talking about names and addresses. It's obviously going to be higher than that. It could include financial information, health information, information that, if disclosed to a third party, could cause the data subject distress. We're not talking here about reporting to the ICO, because if you've been to Stacey's session, the ICO require us to report incidents where there's a risk to the rights and freedoms of data subjects. So there are actually two criteria that you need to bear in mind when you're thinking about reporting. So it's to the individuals, it's where there's a high risk to rights and freedoms. To the ICO, it's where there's a risk to the rights and freedoms. Facilitate the exercise of data subjects' rights. This is all about, for example, making sure that you've got provisions explaining, for example, on your website, which show how people can make subject access requests or complain. So moving on to subject access requests, of course, we've all been dealing with subject access requests within 40 days, and now, of course, responses have to be provided to requests within a month. We don't get many subject access requests. I know that some local authorities do. We get an awful lot of freedom of information requests, which of course aren't changing. Do many of you get a lot of subject access requests? That's Laurie, isn't it? How many?
On an average year, around 500.
Right, so the change in timescale is probably going to have an impact on your clearance, possibly, depending
it'll benefit us, though, because 97.7% of social care SARs, which by their very nature are complex, so we will be claiming the additional 2 months, for sure.
Yeah.
So it's good news for us.
That's the other point, that if you can't respond within the month, then you have to tell the data subject the reasons before the month expires. and how to lodge a complaint with the ICO or seek a judicial remedy. Again, that's something new because I'm not aware at the moment that if we delay a subject access request response, that we have to tell them that they can go to the ICO. So there's a bit like the freedom of information responses where you have to put standard paragraphs in. Responses are to be provided free of charge unless they're manifestly unfounded or excessive and repetitive. Again, I don't think there's been any guidance on that, but that's something that we'll follow. And as now, we can seek to confirm the data subject's identity. So that, again, if we don't know the data subject or we haven't dealt with them in the past, we can require them to provide evidence of who they are, where they live, etc. And we can also provide information from privacy notices by standard icons. So this is obviously on the website. We've just changed our website and are looking to put icons up so that people can get lots of information there. There is a lot of guidance from the ICO on privacy notices, which has been updated this last year. And it's specific to GDPR, which gives the rules, including covering Articles 12, 13 and 14. They're more detailed and specific than the current Data Protection Act. And try to make sure that the notices are understandable and accessible. A previous organisation I worked for, the privacy notice ran to several pages. It was a bit like those things that you see when you sign up for some insurance or something, with, in very fine print, and that's not really on anymore. So the guidance does suggest, and it's quite helpful actually, and one of the things that we did, and I'll give you an example here. You won't be able to see this from where you are, I don't think, but this is an example of a privacy notice that we did for our leisure centre. I've tried to make the first part really generic, so you might think in terms of your authority of, the expectations are, what information do we collect from you, why do we collect it, etc., who might we share it with? And then think about the other areas. So this one is specific to our leisure centre. But you might want a different one for housing benefit. In fact, we've got a slightly different one for council tax benefits and housing benefit. And you might need a different one for other services. As I said, this is an example that we've done. You're welcome to have a look at it. You're welcome to adapt it or use the headings are the important things because they're taken from the ICO's guidance. So it's what do we collect from you? Why do we collect it? Who do we share it with? What do we do with your information? How long do we keep it? And how can I access the information that you hold about me? We've got, as I'm sure you've got, a website for allowing people to make subject access requests, and that goes onto it, and it also allows people to write to us as well. Again, and it was touched on in Lynn Wire's session, the data protection officer has to publicise their contact details, but we've not interpreted that as meaning the personal name, but I've got a data protection officer email address that comes to me. How many of you went to Laurie's session earlier about privacy, data protection, impact assessments? Did many of you go? A few people. Some of this was covered in Laurie's session, and I don't want to labour the point too much. Laurie's given some really helpful advice, which is on the website, examples of what a privacy impact assessment should cover. And there's a lot of guidance on the ICO's website as well, including a template. Have many of you been involved in doing a privacy impact assessment? I mean, they're referred to as privacy impact assessments at the moment, but they morph into data protection, data privacy impact assessments. Have you, any of you done them? Yeah, nods? Good. Again, although it was touched on in the Data Protection Officer session, it's not the role of the DPO to do the privacy impact assessment, but it's your role really to make sure they pass muster and help your organisation to do them, particularly service managers or project managers who've got new initiatives. So what do? Well, they help organisations to identify the most effective way to comply with data protection obligations. There is an assumption that they are an integral part of taking privacy by design. They're not actually new. I first came across privacy impact assessments about 10 years ago when they were raised as part of a separate review. And when I was in a government department, they were obligatory for government departments to use for any new initiatives. And they had to be complete as part of the normal accreditation process. All that is from the ICO's website. It sets out the circumstances in which an impact assessment must be carried out. When they have to be completed before where the processing is likely to result in a high risk for the rights and freedoms of natural persons. That is reminiscent of what was said before about the risks of rights and freedoms of natural persons. This is mentioned a few times in the GDPR. The data protection officer has to be consulted, so you basically have to sign them off. And the ICO is going to publish examples of processing operations that will require an impact assessment. And finally, you must consult the ICO if the DPIA indicates a high risk remains despite the measures. That's going to be an interesting challenge. Is that something that you would do automatically, or are you going to discuss that within your organisation? Anyone? Would you automatically see a data protection impact assessment that you didn't like? Are you going to just contact the ICO yourselves, or are you going to go back to the senior officer? I think you probably want to discuss it, wouldn't you, first? Because this is really a safety valve, but it's also putting a responsibility on the organisation to consult if there's still a high risk after measures have been taken to mitigate it. They must be undertaking the following cases: systematic and extensive evaluation of personal aspects based on automated processing, profiling, and on which decisions are based that have a legal impact on people, processing a large scale of special categories of data: health, racial, ethnic origins, sex, life, political opinions, etc., and systematic monitoring of a public accessible area on a large scale. I think that's probably CCTV, that last one, isn't it? Any other thoughts as to what that might be? I think it's CCTV. I don't think we do monitoring of other areas. How do you feel about that? Are you happy with all that, or any thoughts or concerns? No?
Social media and citizens, social media and citizens engaging with their council through those channels ever impact this? I'm thinking about the last one where you're monitoring on a large scale.
Well, I did interpret if we were monitoring social media on a large scale, but again, I'm not sure we'd be doing that on a, again, it depends of the scale. You're probably not talking about looking at for example, our social media comments on our own website. And bear in mind, of course, it's talking about large scale. So it might be, if we're keeping an eye on what's being said on our Twitter account, I'm not sure that amounts to a large scale. It depends if we've got thousands and thousands of entries, which I know we don't have. But it's, I know it's something that we're expecting the ICO to give us a bit more guidance on. have any of you had any other thoughts about this? Again, these are things that you need to bear in mind.
What about things like CCTV imagery?
CCTV,
and particularly, right to be forgotten. Could someone say, I want you to remove the record you've got of me walking down the high street with my girlfriend last Saturday, or something silly like that?
You'd have to, obviously, they'd have to be identifiable. Again, I think we've yet to cross this bridge where someone comes to us and says, can you find me on this CCTV image? Laurie, you want to say something?
Sorry, in relation to CCTV, the right to be forgotten wouldn't apply because it's not consensual processing. We're doing it's a public task for public safety. So, not all of the rights would apply anyway. Yeah, I take it exactly that way, David. It is around CCTV, and that's what you're required to do, the DPIA, on your use of CCTV within your environment.
Thanks, Laurie. I think the important thing to remember on this one is that this is really, for all intents and purposes, this is talking about where you're introducing a new system. So think about that, because if, as soon as you introduce a new system, and I know it's 25th of May, but in fact, think about it from now on, that you should be doing this sort of thing. Again, I don't know whether... I was actually at a CCTV meeting last week, and I don't think many councils will be introducing new systems because they're very expensive at the moment. But and this is not retrospective either. But obviously, if you change your system, then you'd have to conduct a DPIA. I'm nearly at the end of the session. The content of the DPIA, Article 35, use the ICO's guidance. And again, Laurie's presentation is very helpful because it covers a lot of the headings. If you have to conduct prior consultation with the ICO, then it's Article 36. And Article 25 talks about data protection by design. One of the things that we've introduced in our council, and I know it's a small authority, but I work for the CIO, and basically any requests for new IT systems or any changes to existing systems have to come through him. So we're using that as the hook to identify any needs for DPIA so that no one can introduce a new IT system without considering a DPIA. And bear in mind, of course, most of the systems that we'll use in local authorities will be processing personal information in some respect. So again, it's useful to think about, as was suggested in one of the earlier sessions, you don't want someone coming to you saying, we're introducing this system tomorrow, can we have a DPIA? You need to make sure that it's built in at the outset. And this is where data protection by design and default comes in. I don't know whether Chris Pounder mentioned this morning, but there's a lot of useful information and other resources on the French National Data Protection Commission website. Did he mention it? CNIL. It has a lot of relevant stuff, bearing in mind that the head of the CNIL will probably be head of the relevant EU Data Protection Board. And there's lots of stuff that's in English. It's all in English. And there's even some software on how to prepare a DPIA. Which I've decided not to download.
My CCTV manager is rather aggrieved that there's no longer going to be a £10 fee for data subject access requests, because he gets a lot of members of the public saying, can I see CCTV footage of my car which was bumped into, etc. So I'm just exploring with him whether there might be a way of charging for the administrative costs of producing the information. What's your feeling about that?
To be quite honest, I've been a little bit apprehensive because we don't get many subject access requests, and I suspect, the fee might be an inhibitor at present. There is provision if it's, I think, voluminous or something like this, but most ones are going to be free, so I think you're going to have to accept that. Does he get a lot?
I think he gets a lot, yes. So is it only if it's voluminous and you can't for example, charge for copies of things?
Well, basically at the moment we can charge £10. I know it's higher for NHS organisations. I'm just having a look. I don't know whether anyone's seen this elsewhere. Right of access. Right to obtain from the controller confirmation as well as personal data. Where is it? Has anyone else come across this issue?
I haven't seen nothing specific, but I think the main rule is
no one should have to pay for their data that they own. So that, like, this charge is abolished.
You can charge a reasonable fee when a request is manifestly unfounded or excessive, particularly if it is repetitive, unless you refuse to respond, or is for further copies of the same information.
So it is quite prescriptive.
You need really to look at the guidance on that one. My assumption is that it's going to be free in most cases. But obviously, if it ran into, it's strange this because last year I made a subject access request to my insurance company and paid the £10, and I've never seen so much information they sent me. They sent me 2 or 3 CDs. It was only a simple request. I had pages and pages of printouts. I was quite impressed actually. But I know some of our subject access requests do run to several pages, to many pages.
The problem for my CCTV man is that he has to go and research, he has to go and look through hours of footage, and it's really quite onerous.
Right. I think it's something you need to look at.
From my understanding, you have to really push back on them to narrow it down. So you have to go back and say to them, okay, can you be more specific before you even consider asking for money?
Yeah, at the moment, if someone makes a subject access request, you can ask them to be specific as to what information they want. So that's something to bear in mind. Also, if for example, I know we've encountered that issue where someone has their car's been damaged by another vehicle, but they've told us the times, and we've been able to find it fairly quickly. But you know, if someone said, "Oh, well, I parked my car in your car park last week," you know, it could have been there several days. Well, that's not being reasonable, is it?
But you generally wouldn't release other people's personal data to them. So if they're doing it because they want to find out who bumped into their car, that's the personal data of someone else. So you have to be really careful about that. So unless they're absolutely saying to you that they're going to take it through a legal process and it's their solicitors who are asking for that personal data, then I would push back and say, well, it's somebody else's personal data which is protected under.
You could obviously have regard to, on that one, to currently Section 29. You know, it's processing. Again, it depends whether it's an identifiable vehicle, etc., of the third party. But you know, your exemption under Section 29 might apply, prevention or detection of crime, etc. So there could be a good reason to release it. There was a very interesting case. I don't know whether you saw it. That was reported by the ICO a couple of weeks ago, where a member of the public, or in fact he was a company owner, saw a vehicle with a registration plate that he quite fancied, and he pretended to the DVLA, who he wrote to. He said that the vehicle had been in a car accident with his, and he got the name and address of the owner from the DVLA. And he then, stupidly, in my opinion, he wrote to the owner and said, "Would you sell your car to me, because I like your number plate?" And the individual promptly reported him, I think, to the DVLA, and they reported it to the ICO, and he got prosecuted, which I thought was quite a salutary lesson for him. But again, I'd be looking at, you know, if someone has damaged another vehicle and driven off, then potentially that is a crime, and that could be a good reason for releasing that information to the injured driver.
Just about data processors, so you're talking about health data for data privacy impact assessments. If you're contracting out something like your occupational health, would any changes to the system, would you be required to do data protection impact assessments on any changes to their systems, or would you be required to monitor any changes that they make to their systems that impact the data that they're processing for you? Or
I'm just trying to think what it says in the PPN that Tim referred to this morning, because if you have a look at the PPN, and in fact, if you look at the guidance in the, well, I can't remember which one it is in the GDPR, it talks about writing to your data processors and asking them certain things. They have to give you certain assurances. One of the assurances is that they will not do anything that breaches the GDPR. It's actually quite restricted, but I don't recall that it said that they had to tell you if they changed the processing, because they should be only be processing the data on instructions from you. And they can't use the data in a different way to that under which you've agreed in the contract. So again, I think it's worthwhile looking at the PPN. Incidentally, the PPN, the guidance on the relationship between data controllers and data processors is mandatory for government organisations, for central government. It's not mandatory for local authorities, but I'm going to suggest to my authority that we use it as we effectively introduce it, and that it's mandatory because it covers all the things that are in the GDPR in terms of the requirements for the relationship with data processors and data controllers. I mean, we have got a lot of data processors, I'm sure you have, and these are quite restrictive. And I guess many data processors will be quite surprised at the tightness of the arrangements, but it's effectively putting into law what should have been in contracts anyway.
David, in terms of your fair processing notice, if you've completed one for your council, I just wondered about the aspect about voluntary or obligatory aspect of it, that part where you have to state that publicly. Just wondered how you approached it, based on that most local governments by definition really collect information on a voluntary basis, but if it's not given, then the service cannot be carried out. So how did you approach that input in the...
In terms of communicating, I think we obviously we'll have it on our website, but we also, at the point that we're collecting information from the individual, we should be issuing a privacy notice, which is quite an interesting one. So if we are collecting email addresses, for example, we should be making sure that the person is aware of all those things that are in the privacy notice. So it's at the point that you collect the information that you should be giving the privacy notice. We've got our housing benefit application forms. They've got the privacy noticing incorporated, where it's completed and manuscript, for example. So it's got to be at the point that you actually collect the information. It's actually in Article 28. Oddly, it doesn't actually say that where the data processor changes the arrangements for processing the data, unless they're passing it or they want to pass it to a third party or transfer it abroad. So all it does say is if any instruction infringes the regulation, or if there's going to be a breach of the GDPR. So there's a presumption, I think, that the data controller will have seen the data processor arrangements beforehand. I wanted also just to touch on something I mentioned earlier, which was about notifying data breaches to individuals. In the GDPR, it talks about where there is a high risk to the rights and freedoms of individuals. And again, we know that a lot of incidents are reported to the ICO, and I don't think Stacey's with us at the moment, so I think I can speak fairly freely. When you're thinking about reporting an incident to an individual, think about the effect that will have on the person. And you should really be thinking about, well, if there is an incident, it's got to be one where there's a high risk. So you're talking about impact on financial information, health information, etc. If, for example, there's an accidental disclosure of name and address, does that create a high risk to the individual? It might if they're a local celebrity, but for ordinary people, it might not mean much. So think about when you tell the individuals what impact it will have on them and what you want them to do. So, for example, if it was financial information, you'd want them to contact their bank or building society, etc. If it's health information, depending upon the sensitivity of it, you'd want them to be aware that that information is disclosed and the possible impact on them.